Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Yes, we are coming to you from Hawaii this week, and here is a weekly recap of all the top stories conveniently located in one place. We hope you enjoy it. Have a wonderful day, and we'll see you back in the studio on Monday.
All right, lawyer.
Next on the docket, Richard Allen. That's right. We have a hearing coming in the Richard Allen case. When I say soon, nothing's gone soon or quick in this particular case either. And hey, it's going to be fun. So the Carroll County Special Judge Francis C. Gull will have a Richard Allen-related hearing beginning late next month. Now, the filings in the circuit court reveal that several motions concerning Allen's legal case are expected to be heard over 3 days. The hearing will begin on July 30th and go through August 1st and start at 10 a.m. each day. Now, Mr. Allen is accused of killing 13-year-old Abby Williams and 14-year-old Libby German near the Monon High Bridge in Delphi back in 2017. That's Delphi, Indiana, to be specific. Anyway, since he was arrested back in October of 2022, there have been a number of back-and-forth legal exchanges and claims, as well as the changes in dates between Allen's attorney and the state. Anyway, the 3 days of hearing are expected to cover various motions filed over the past few months between the prosecution and the defense. This includes evidence disputes, including a request by Mr. Allen's attorneys to dismiss ballistic evidence as well as claims surrounding Allen's status in the jail. Now, as you may recall, back in April, Allen's attorneys claimed that Allen was not read his Miranda rights before his interview in October of 2022, and the attorneys also claimed the other highly unusual police behavior toward Mr. Allen, including missing portions of footage from the interview and keeping Allen in a small windowless interrogation room for more than 2 hours before he was allowed to leave. Well, Mr. Allen's case is scheduled to start on October 14th. Obviously, this comes after the case has been pushed back a number of times. Like I said, October 14th through November 15th is the date. We'll just have to wait and see. I can tell you how these motions will be ruled upon. Here you go. My prediction, my crystal ball. Defense motions denied. The motions filed by the prosecution, they are hereby granted in whole or in part, but they will be granted. Defense, you get nothing. Zilch. Nada. Nothing. Nothing. Zilch.
You get nothing. You lose. Good day, sir.
You get nothing.
All right. Next on the docket, is Alec Baldwin actually going to get his case dismissed? Well, we brought you the motions hearing last week. The whole issue, or one of the issues that Alec Baldwin's attorneys are arguing for, is that, hey, the prosecutors in this case turned the gun over to the FBI. The FBI was going to do their function test to make sure that the gun was, in fact, a functioning firearm. And normally when they do a functioning test, the firearm experts, they take it through the procedures of cocking the gun, make sure it fires and things of that nature. And they oftentimes shoot and expel a round down range at a fire range to make sure that it can expel it. They will also do various function checks, particularly if there's an allegation that the firearm malfunctioned, as Alec Baldwin has so alleged. I've seen this in a case. They will beat the bloody hell out of this. They take literally a rubber mallet and they whack it in all different directions. Well, in this particular case, apparently the FBI was whacking it and it broke into 3 different pieces. All right? And that was one of the reasons why the case for Alec Baldwin was originally, they had the charges dismissed. And then they refiled. Why? Because they were able to put Humpty Dumpty, i.e. the gun, back together again. Now, this issue came up in the Karen Reed case as well, and the judge allowed it in. Hence the reason why I don't think the judge is going to dismiss the case. The gun expert from the FBI can explain what took place. The prosecutors can explain what took place through the expert witness. And they can say, yes, we broke this thing, but we fixed it, and it will go to its weight, not its admissibility. All right? It wasn't exculpatory evidence because all the pieces were still there. The defense could have looked at it, or probably should have looked at it beforehand. case that I had, we demanded that we look at it first when we had a firearm issue, and because we didn't want them whacking it and possibly breaking it or adjusting what is possibly broken in the firearm. So I find it highly unlikely that the judge is going to throw this out, basically saying it's a destruction of exculpatory evidence, because the evidence is there, the experts can testify to it, and the defense can cross-examine and have their own expert testify to this. Now, this trial is coming up rather quickly, so we are going to bring it to you. Now, Alec Baldwin faces 18 months in prison if he is in fact convicted. Now, some people, I mentioned this the other day, said, no, Scott, he's not going to go to prison. He's Alec Baldwin. Well, that's probably what Hannah Gutierrez thought too. I'm not going to prison. I'm Hannah Gutierrez. I'm an armorer. Well, somebody died when it was preventable. And guess what? I think if Alec Baldwin is convicted, he faces the real possibility of going to prison. And remember, the case isn't that different from the one for Hannah Gutierrez, except Alec Baldwin made a lot of different statements throughout this whole thing. Oh, I didn't pull the trigger. It just went off. Couldn't have happened. It's everybody else's fault but mine. He went out there and told American people on TV that he didn't pull the trigger. And I'm telling you, if you go back and look at my videos, we've done lives where I brought in my antique firearm, very similar to this. This thing did not just go off. So, Alec Baldwin, we give you the presumption of innocence. I wish you well at trial, as I would any defendant when the resources of the entire state of New Mexico comes down on you, as well as the FBI and things along, and all those other sundry organizations that are trying to convict you. But you shouldn't have been so cocky early on. There's two types of people in the world, Mr. Baldwin, those that are humble and those that are about to be. And I think that you are going to be humbled, no doubt indeed.
Lori Vallow, yes, she's back. Remember, she got convicted there in the great state of Idaho for 3 counts of murder, got 3 consecutive life sentences. Her husband, Chad Daybell, well, he got the death penalty. Well, Lori Vallow has that pesky case of where, she just tried to, she succeeded, I guess, in conspiring with her brother, allegedly, to kill Charles Vallow down there in Arizona, and she has been charged. Well, her attorneys have said, we need more time. The defense team for Lori Vallow is moving to continue the August 1st, 2024 trial date. Well, guess what? Lori Vallow objects. She says, I want to go to trial, and I want to go to trial now. So the court's going to have to decide whether her right to a speedy trial trumps her right to her Sixth Amendment right to effective assistance of counsel. Now, the public defender says, hey, Judge, there's over 100,000 pages of discovery review. Approximately 88,000 of those pages were disclosed only in February of 2024, and there's no way that they could possibly get through this. The government has endorsed some 45 witnesses, and the defense has requested 3 pretrial interviews in this case and is awaiting their scheduling, but the clearly nowhere near completed their pretrial interviews in this particular case. So you may say, well, what's the big deal? Just drop all your other cases. Well, Lori Vallow is being represented by the public defender. Guess what? These public defenders, they have probably 200 other cases that they need to worry about, not to mention the new ones that come in, the other cases that have been going on. It's not like they just get designated one particular trial. This may be one of probably 10 or 20 homicide cases that the public defender represents individuals on in other cases. So, therefore, it's going to be interesting. Now, Lori Vallow ultimately has the right to say, I object. This same situation happened in her case in Idaho, as you may recall. It ultimately saved her life because she didn't receive the death penalty because the judge imposed a sanction against the prosecution for turning over discovery late. And she says, I'm not waiving my speedy trial. Let's go. Let's do this thing. Let's rock and roll. And the judge says, fine, as a sanction, because we're going to do this case and we're going to do it within the speedy trial rights. Prosecution, death penalty is off the table. It probably wouldn't have happened given her mental health issues. And even if she was convicted or found guilty and then ultimately sentenced to death in Idaho, it probably would have been reversed. But here in Arizona, there's no indication that they're going to go death. And therefore, the judge will have to decide whether their attorney's right to prepare trumps her right to a speedy trial. I say, let's go August 1st. Ladies and gentlemen, these public defenders need to go to their boss and say, hey, big case, we got to prepare. Transfer some of my other cases to other individuals so that we can prepare for this particular case. It's that simple, ladies and gentlemen. But, we'll have to wait and see. Now, certainly this may create a rift between Lori Vallow and her attorneys, right? When the attorneys are saying, I need more time to prepare, guess what? That also is giving the prosecution more time to prepare and be ready. My guess is the prosecution will be ready on August 1st. They've had this case for years. It's not that difficult. Heck, at one point I had the entire discovery downloaded from the case in Arizona, and it was about this big. When I say this big, it was probably on the table. It was about, 2 feet tall. So it's not that complicated. Yeah, there's a lot of body cam videos, but really it is what we've all seen on the videos as it relates to the Netflix series about Lori Vallow and the timing of how she went here and there. And Charles came back, and guess what? Her brother just happened to be there and shot Alex Cox. And obviously, it wasn't self-defense. Now, the police probably should have arrested her that particular day. Shame on them for not doing that. Karen Reed. Yes, the Karen Reed trial. Where Karen Reed is accused of running over her former police officer boyfriend and leaving him to die. Anyway, the jury is telling the judge, after some 22 hours of deliberation, that they believe they are unable to reach a unanimous verdict. So did the judge declare a mistrial? Not yet. She basically gave them what you refer to as a modified Allen instruction. And it says, hey, jury, go back and look at all the evidence. Stay firm in your convictions. If you believe the prosecution hasn't proven their case beyond a reasonable doubt, that's okay. But listen to all of the other jurors. Keep an open mind. Look at the evidence and see if you can't reach a unanimous decision one way or the other. Why? Because nobody likes a retrial. Everybody has to do it all over again. It's expensive. It's time-consuming. It's stressful. Nobody wants to do that. But the judge said, hey, we've been here for 30 days, oftentimes for very short periods of time. But the judge says, go back and try again. 22 hours isn't long enough, given the fact that we spent 30 days on sentence, that we spent 30 days presenting the case to the jury. Now, obviously, the jury is deciding whether Karen Reed is guilty or not guilty of second-degree murder, which in Massachusetts is punishable by life in prison with the possibility of parole. Now, she also faces lesser charges of manslaughter while operating a vehicle under the influence, punishable by 5 to 20 years in prison, as well as leaving the scene of an accident resulting in death, which can result in a prison sentence of 10 years. Now, this is not good news for either side, ladies and gentlemen. The prosecution, obviously concerned, maybe didn't meet their burden of proof, at least not to one juror. And then you have the defense. They don't want to do a mistrial either because they have presented the jury with all they have. And guess what? If they have to do this all over again, prosecution knows exactly where they're coming from, and it just doesn't have the same impact second time around. The prosecution can fix it. I can tell you my own personal experience, when there has been a retrial, it has never gone well for the defense. It just doesn't happen that way. I had one case where we got to try it multiple times, and it mistried multiple times, but ultimately at the end of the day, it didn't work out so well. Anyway, we'll see what the jury ultimately decides to do. Maybe they'll think about it over the weekend, come back, maybe somebody will change their mind, probably talk to a family member, friends, read the newspaper. Oh, just kidding. Jurors don't do that, right? I like to think they don't, but oftentimes we know they are exposed to outside influences. We'll see if that's going to take place here. Anyway, we are bringing you the Karen Reed jury verdict watch with the counter, 22 hours so far. We'll have to wait and see.